So who can become a juror? In Australia, which is fairly typical of countries that use juries, the jury consists of members of the general public aged between 18 and 70. A computer is used to select names at random from the electoral rolls. A questionnaire is sent out to potential jurors to determine their availability and eligibility to serve on a jury. From this, a ballot is conducted and a summons is sent to those who are selected. Some people, such as those who have served prison sentences, are actually not eligible for jury service. Once potential jurors turn up to the courthouse, there are two further processes. Groups of potential jurors will be called to attend a courtroom for selection onto a trial. How are they chosen once they turn up in the courtroom? Well, I'll describe the process that applies in many jurisdictions, although the details may change from place to place. In some jurisdictions, more information is known about jurors during the selection process. Cards showing the names, addresses and occupations of potential jurors are placed in a rotating box and picked out at random. When called, each person walks to the bailiff to take an oath on the Bible or make an affirmation. During this part of the trial, called voir dire, potential jurors can be rejected. At any time before the bailiff begins to recite the oath or affirmation, either the prosecution or defence can raise an objection to a juror. A juror can be challenged because the prosecution or defence simply doesn't like the look of that juror. This is called a peremptory challenge. In some jurisdictions, there are limitations on how peremptory challenges can be used. For example, in the United States of America, you cannot use this type of challenge on the basis of race alone. Although some research by Summers and Norton in 2007 suggests that this race-based challenge still occurs even when lawyers are able to give non-race-based reasons for their selections in such cases. A juror can also be challenged for a different reason. They can be challenged because of a presumed or actual partiality. This is called a challenge for cause. The defence and prosecution can only make a limited number of each of these types of challenges. The number varies from jurisdiction to jurisdiction. The judge may also ask potential jurors questions to determine whether they will be able to discharge their duty as a juror effectively. For example, the judge might ask if anyone knows the defendant in this particular case, or whether anyone has read media coverage about the case or has already formed an opinion about the guilt or innocence of the defendant. In some jurisdictions, such as in some states in the United States of America, potential jurors can be asked to complete lengthy questionnaires that are designed to assess prior attitudes and potential biases that jurors might hold. For example, potential jurors in the trial of Phil Spector were asked to complete a 15-page questionnaire. Those jurors in the O.J. Simpson criminal trial were actually asked to complete a 75-page questionnaire. These questionnaires can be informed by additional surveys of the community prior to the selection process to identify the links between characteristics of potential jurors and how positively or negatively they view arguments and evidence specific to the present case. Trial consultants sometimes also make use of mock jurors, which are people pretending to be jurors in the case, and focus groups to further enhance their understanding of how different types of people might react to the case. With this additional information prior to jury selection, trial consultants are supposedly in a better position to identify those potential jurors in the jury pool who will react most favourably to their side of the case. In addition, and in cases involving the death penalty in the United States of America, jurors have to also be death qualified to serve on such trials. This means they have to have no moral objection to imposing the death penalty should the defendant actually be found guilty of the charge. If the defendant changes his or her plea to guilty, or there is some change in scheduling, or perhaps enough jurors have already been chosen, it is actually quite possible for a potential juror to go through all of these processes and turn up to court for jury service, but never actually be selected onto a trial. So take a look at the image of potential jurors in the next section and read the basic description for each. Who would you select for the case you've been following so far in this course? Think about why you might select or object to each person. You can indicate the people you would challenge, that is reject, in the poll that follows.